The March 29th meeting of the Rules Committee will be in order. Councilor Snell, would you be okay?
Thank you, our gracious Heavenly Father, for this beautiful spring day, Lord. Lord, be with us as we go through our committee meeting today. We pray for wisdom, pray for understanding. We pray for everybody that's attending this meeting today. Be with us, Lord. Thank you for everything. Amen.
Will you call the roll? Here.
David Washington.
Here.
Bill Edwards.
Here.
Jack Baker.
Here.
Joe Bird. Julia Taylor. Jody Fishingham. Here. Meredith Fraley. Janelle Fulbright. Here. John Garvin. Frankie Harden. Hannah Glory Jordan.
Present.
Dick White.
Here.
Travis Snell.
Here.
David Wilson.
Here.
Karen Cowan Watt. Honey. We do have a form.
Entertain a motion for the approval of the February 23rd, 2012 minutes.
I make a motion to approve.
Second. Moved by Councilor Hargis, seconded by Councilor Senior. All those in favor say aye.
Aye.
All opposed, same sign.
Abstain. Wasn't here for the bulk of the meeting.
Before we get into the rest of the agenda, just a personal privilege. Mr. Sutherland from the Housing Department is here. He just wants to pass out the applications for the new housing program. We can't entertain discussion on it. We're not on the agenda. It's just so he can get on about his business. We're going to allow him to pass that out.
Okay, two things for you. You all had requested the copy of the policy, the approved policy. Got that? And then we've got the application has a little fact sheet on the front of it that tells about the program. If you all have any questions or anything, give me a call. We're going to start taking applications on Monday. They'll be at all the housing locations, sub-offices, and everywhere then. Just if you have any questions, be sure and give me a call.
Mr. Sutherland, would you mind leaving a copy for Gail to scan so we
Give me one back.
Yes, due to some time constraints, I would like to make a motion to move 1, 2, and 3 of new business forward before reports, and if nobody has any objection, maybe accept reports, because we've got a full agenda due to time constraints.
full agenda? We have a motion to move, well, if we're going to, Councilor, if we're going to move those items ahead of reports, then, and if we're dispensing with reports, then we're really just dispensing with reports. I have a motion to dispense with reports. Second, Councilor Hargis. All those in favor, say aye. All opposed, same sign.
Aye.
And for the folks, the administrators that came over, we appreciate it. We know that you come over to make reports, and you've got written reports. We've had some heavy agendas the last few months. We think the load will get lessened going forward. So we'll get back to the business of oral reports because they're very important. Councilor Ingram.
Should we hold over David Justice over later on, or is he coming to the 4 o'clock meeting?
Yeah, Mr. Justice, I would think would be here for the meeting. He's in the back. Are you indicating he'll be here later, Mr. Justice?
Yes.
All right. Thank you. Thank you, Councilor Ingram. Councilor Wentz.
So I tried to work with you on the UKB status of land in the trust and the 2003 constitutional and the Freedmen updates that I had requested from the Attorney General, which would be during reports. So now I will not get to hear the update I had requested for the public.
Would I'd entertain a motion to ask the Attorney General to give his reports and to accept all of the reports as written. Would you make that motion, Councilor?
Yes, so moved.
Second. All those in favor say aye.
Aye.
All opposed, same sign. And Mr. Hembry, I think that we need to get. Let me ask Councilor Fishingham, did we need to get to 1, 2, and 3 before we get into any extensive discussion?
Yes.
Okay. Not to overburden the record here, but make a motion, put 1, 2, and 3
1, 2, and 3 ahead of
Mr. Hembry's report.
Yes.
Do I have a second? All those in favor say aye. All opposed, same sign. We now move to new business item number 1. Is that that correct, Councilor Fisher? So we're going to do the first three appointments before we get to Mr. Hembry's report. So, Councilor Fisher, would you introduce this resolution?
Yes, this is a nomination of Josh King to be a member of the Commission of the Housing Authority of Cherokee Nation. He works in my county. His wife, I'm not quite sure if she's here, I'm looking around. He's also from there. Could we have him come up and say a few words, please?
Certainly.
I would like to move for his approval.
We have a motion for his approval. Do we have a
Second.
We have a second. Mr. King, would you come forward? Hello, sir.
Hello. My name is Joshua King. I am the Assistant District Attorney in the Adair County office for the 27th Judicial District. I'm a member of the Cherokee Nation. I am a participant through the Housing Authority through the Title VI program since 2004. My home was financed through that program. Chief asked me if I would be interested to serve on this board, and certainly am interested in potentially serving on this board. How much information you'd like from me, but that's in a nutshell what brought me here, or to submit a resume for that position.
Thank you, Mr. King. Do we have any questions for Mr. King? Councilor John Watts?
Thank you. How do you feel about Terra compliance?
I think it's important if we can. I think it's important to try and achieve Terra compliance, that if we can do business with businesses that are employing Cherokees, then we need to do that. We have the resources to use our money, our housing money, to build homes for members, and we can do that and also give jobs to members. In doing that, I think it's a good thing. I think it should be done.
Thank you for being here today for all this, sir. Thank you, Mr.
Thank you,
Chairman.
Councilor. Any other questions for Ms. King? Ms. Sutherland, did you have something to say?
I just want to throw in my endorsement of Mr. King. How many years it's been now, but he actually was on one of my baseball teams. So he was a younger lad. He's grown up. He's done well, and proud of him. And be happy to have him on the board.
Madam Speaker?
Yes. And I do want to expose to the body, this is my former son-in-law. He was married to the daughter that we lost in 2005. I have had, when his name was submitted, I did ask both the Attorney General and our lawyer to review the Sunshine Act. He doesn't want to cause me any trouble. I certainly don't want to limit his ability to help the Cherokee Nation. You might want to have Mr. Hembry address that issue.
I reviewed the request and compared it with the Sunshine Act, and there was no conflict of interest of a former relationship as such, and so there would be no conflict that would exist.
I would concur with that, Mr. Hoffman. Just the language in the act, the death of Craig Gordon terminated that relationship, and there is nothing that prohibits her from voting.
Very good, thank you. Madam Speaker, anything further?
I just wanted to expose that to the body so that all minds would be clear.
Any other questions for Mr. King? Seeing none, call the question. All those in favor of the nomination say aye.
Aye.
All opposed, same sign. Thank you, Mr. King. Congratulations.
Thank you. All of you, thank you. Hold on.
All right, we now go to new business item number 2, and Councilor Fishinghawk, would you like to take this again since?
I'd like to yield.
All right, yield to the speaker, Madam Speaker.
I would like to introduce to the body Bobby Mayfield. Mr. Mayfield resides in Hobart, Oklahoma, so I know him quite well. He is a Cherokee member, long-time person in the construction industry, and I would like to set forth his name to take a seat on the housing board.
That's a motion to approve. Who's second? Second by Mr. Byrd. All right, sir, welcome.
Yes, I've lived in the Hobart area all my life and run several businesses. Me and my wife, Diana Gritz Mayfield. And the chief asked me to serve on the board, and I'd be willing to serve if y'all accept me.
Do we have any questions for the gentleman? Councilor Conlon.
Thank you, Mr. Chairman. So what is your take on our Ontario law and how you would apply it at the housing authority?
I love the law myself. I think we should make more use of it, and anytime we can put Cherokee people to work, we need to.
Thank you so much. I appreciate it. Thanks for being here.
Any questions for the gentleman?
I'd like for him to introduce his wife. I believe I saw her back there.
She's better looking.
Thank you. All right. We'll take the vote on the question. All those in favor say aye.
Aye.
All opposed, same sign. All right.
Thank you.
Carries. Congratulations, sir.
Thank you.
New business item 3, nomination of Ms. Chapman Plum to the Cherokee Nation Foundation. Councilor Jack Baker, would you?
Yes, I make a motion we approve it.
Second.
Second by Councilor Garvin.
Sorry, Mrs. Plum is in the audience today. I'm Kimberly Gilliland, I'm the executive director, and it's my honor to introduce Mrs. Chapman Plum to our board of directors.
Any questions for Ms. Chapman Plum? Councilor Conlon.
Thank you. I just have a short statement, is that I want to thank you for continuing your service to the Cherokee Nation despite this last year's election cycle.
It's a little more fun.
Yeah. Welcome to something, although there's no compensation, we appreciate your willingness to serve again.
I think it's a good trade.
Yep. Thank you.
Well, my grandmother was an original enrollee. She was born in 1900. She taught in one-room schoolhouses all over Cherokee County. My mother was a lifelong educator, and the future, the 50 and 100-year future of our tribe lies with the efforts of organizations like the foundation. So, thank you.
Anything further on this nomination? All right, we'll move to the question. All those in favor say aye.
Aye.
All opposed, same sign. All right, we now return to reports, and the sole report we're going to receive orally is from the Attorney General. Mr. Attorney General.
Thank you, Mr. Chairman. My report has been submitted, and would entertain any questions. But as to the hold on. As to the issues that Councilman Cannon Watts brought up as to the status of the Freedman litigation, I'll start there first. We just received in yesterday, or maybe the day before, the brief in chief by the appellate Marilyn Vann in the District of Columbia circuit case, okay, the appeal. So we will have an applicable time to respond to that, and nothing was surprising in the brief, so to speak. I feel comfortable that we won in the lower court, and we will win at the appellate level. That's as to the D.C. case. As to the Northern District case, we have a joint status conference due, I believe, April 27th or very late April, and I can get you those specific dates, to which, as I have said all along, my intentions is to get a briefing schedule in place in that case, and intend to have a hearing on the merits. So that's on the Freedman front. Okay, any questions on?
So, Mr. Hembry or A.G. Hembry, in the past, when those get received by the office, we've gotten copied on them, and I don't recall getting a copy of whatever's been filed.
I would be happy to forward that to you, and as to the brief from Ms. Vann, and when we file our brief, we will make sure that the council gets disseminated also.
We had stuff on the website about the issue, and then things were posted. Well, that's disappeared from the website. So is there some way that we can still keep those filings where tribal citizens can go to that, at least the public part of it?
Well, I'm not in charge of the website, but I would make recommendations to the webmaster and Mr. John James that public filings be listed. You need to silence your phone. Sorry.
Okay.
But yes, I will make a recommendation that be disseminated.
Thank you. That's one of three from.
Okay, the second issue is the United Kituah Band land in the trust issue. I am not aware of any new dates or filings that have been issued. I have not obviously entered into any negotiations with Department of Interior or with UKB officials, so therefore there's no news to report on my behalf.
Mr. Chairman, may I?
Yes.
So I have, I think at least two questions. So have we objected, because I've never gotten a copy of us objecting to land in the trust applications, and where is the state's case on the illegal casino here in Tahlequah?
As to the objection, there's been no new filings while I've been in office to object to.
Can we make sure that it got done, though, during that difficult last year?
I will make sure that and that would be a requirement as to the statute that was passed by this council some 3 months ago, I believe.
What about the status of the case on the casino?
I have no control over that. I am going to be meeting with Attorney General Scott Pruitt in the near future, and that will be a topic of discussion. But we're not a player in that, and the Attorney General is, but that will be one of the topics that I will discuss with General Pruitt when I meet with him.
One last thing. So the UKB has a piece of property in Claremore off right of Highway 20, and in the last year they've asked for an environmental, and then it kind of like disappeared. Without staff, I have no capacity. I think I've dead-ended all my research I can do, but I'm concerned that they're going to try to put that land into trust right there in Claremore.
Well, make my office aware of the parcel that you're...
In the inter-office mail already, what I could find.
Okay.
Okay, thank you.
Just make sure that I'm aware of it, and we will follow up on that.
Okay.
And then the third topic, the 1999 Constitution, we're still under it. There's no change in the status there. You know my opinion on that issue, and I've made it quite clear, so there's nothing further that I need to report on that.
Mr. Chairman, maybe I understand it differently or see it from a different perspective, but from my perspective, and I think my constituents' perspective, you'll and me agree or disagree, but we feel like we're in limbo because the last thing that we've gotten is Echo Hawk says we're not under the 2003 Constitution. They're not honoring it. We've got all these issues out there, and yet the Cherokee Nation does not seem to have exerted itself and said, well, yes, Mr. Echo Hawk, it is.
Well, I don't know how I can make myself any more clear than what I have. You have requested an official Attorney General opinion 2 days ago. I will issue that opinion. That will be the law of the land of the Cherokee Nation until overturned by a court of our jurisdiction. And I know we're on video, and I have no problem saying this. Mr. Echo Hawk may be entitled to his opinion, but I know what Constitution that we're under, and I'm going to state that until someone in higher authority, and I'd like to see who that authority is, says otherwise. So I don't know how I can make myself any more clear on that.
So from a sovereign government perspective, where does that put us, though? I mean, that's what I think the unanswered question from the public when we get these questions at our community meetings and such. If they feel like right now we have not exerted ourselves and said, U.S. government, no. Is that Chief Baker's responsibility? Is it our courts? Is it yours? Is it ours? What do we need to do?
There's nothing needs to be said to pay any credence to the opinions of the Secretary. Okay? Our courts have spoken on this issue. Our highest court has. We don't have to explain ourselves to anyone else. If a lawsuit is filed as to that result or as to that contention, I will answer it and I will defend it. But I don't feel ourselves as paternalistic enough to say if someone in the United States government says, well, you're not doing anything right, well, you're entitled to your opinion. Our highest court has spoken on it. And you will have an Attorney General's opinion that will mirror the opinion that I had as Attorney for the Tribal Council.
Thank you, Mr. Hembry. I really appreciate your time today. Thank you.
Okay.
Thank you, Mr.
Any
Chairman.
further questions? I've been monopolized, so.
Any further questions for the Attorney General?
Thank you.
Mr. Attorney General. All right, we now move to the first item under old business is a discussion item which I sponsored, the implementation of an independent information technology service for the Cherokee Nation Tribal Council. I'm content to spend just a moment on this just to say that I think it's still an issue. We do need to be separate, and I don't even know who I would put on the spot if I was going to put one of our staff on the spot, but Doug, would you refresh my memory? There was some research into the topic done at some time over the past year that is separating from Cherokee Nation server. I just want you to confirm that. We did look into that at some point.
We did look into it.
So what we may need to do is look into it again because maybe that information is a bit dated at this point.
That proposal's dated. Matter of fact, the individual that was going to be administering that change from the technical perspective no longer lives in the area.
Thank you, Doug. Councilor Candelas, did you have a comment?
Thank you, Mr. Chair. I would ask that the Speaker and the Deputy Speaker of the Council consider just asking, I believe our current provider is AT&T for most of our backbone and such, because it's such a small group of us, even with staff and cloud computing. I don't know that we need separate physical, especially because we're dispersed geographically. It may just need to be something that's provided as a business issue, like through AT&T or some other existing provider, rather than like bidding out.
We can look into that.
Since it had been done prior. Thank you.
And Doug, we may need to lean on you for that, but we can get with you offline to explore that. Any further discussion on this topic? All right, I'd like a motion to just table this to the next month.
So moved.
So moved by Councilor Harden, second.
Second.
All in favor, say aye. Aye. All opposed, same sign. Table the next month. All right. Old business item number 2, Madam Speaker, would you take that? It's the issue of whether we should move.
Well, I think everyone in this room, of this body, knows that we've got some problems with the roof on this building. My understanding is in order to do anything of the magnitude that we need to do to fix the roof, it's going to be somewhere in the neighborhood of, I believe it was $400,000. And we will have to move because they have to completely remove the roof after we decide that the cost is acceptable. They have to completely remove the roof and then basically start from scratch, salvaging, I guess, kind of the shell. Then we're going to have to come in and do some work, especially for you folks back in that back office where there's been quite a bit of water damage and there's I understand the potential, if not reality, of mold. So in the interim, and we're discussing with admin, because the court's in the same situation. The court needs to move from their current placement to another building also. So we're discussing with admin the possibility of a capital improvements project that will include both the court and this body. In the interim, we need to decide what we're going to do. Short of pitching a tent outside, we're going to have to consider moving. The area at the complex that's commonly known as the pod, now being partially utilized by the Attorney General's office, appears to be available and appears to have sufficient space with some reconfiguring to house both us and the Attorney General. And I see the Attorney General on his feet now protecting his turf. And so I'm actually going to defer some of my time in just a heartbeat to Mr. Hembry. A lot of us have been over to visit the pod, and I think there's been ample time for the last couple of months to kind of go visit the area to see if this is even something that you're interested in. If this is not an option that you're interested in, we kind of need to know that today because we'll have to go looking for space somewhere else. But as I understand it, and I think he's passing around maybe a configuration, that there would be an office for every council person, an office for staff, plus a large meeting room that we, when they did some separation, there would be a large meeting room created that would be bigger than this room. And so we need to know, both myself and I guess the admin needs to know from the point of they're the space givers, is this something that this body is even interested in entertaining, or do we need to go look elsewhere?
Mr. Attorney General.
Yes, and I would defer to Councilperson Watts if she had a question.
I have no specifics to make a decision really in the fact of how long it would be, and then what's the different business cases. You know, what does it look like if we stay here versus if we go over there and do exactly this, how long it is, or what if most of us do not office here because we're not anywhere near the building, we're here like twice a month. So it would make more sense to me that we would just use the council chambers as they exist and vacate this building. The only ones I would be concerned about would be the staff, but we could incur less cost by only moving a few people over, like speaker, deputy speaker, and the staff, maybe a couple of rooms, and be done with it instead of taking up valuable space that the employees are here every day would need. And I think there's three options, but I don't see. There is a reason. We looked at this back in 2004, and it was very clear that the physical separation of the branches of government is really necessary. And I appreciate that we have to do something because of the condition of this building. But again, several people on this body were adamantly opposed even to a temporary, I think, at that point because of the physical separation needed. And we don't need to be here. So I think we could use that existing chamber and save a lot of money and just already have it set up to meet in there even for committee meetings. Thank you. And I was wondering if that's been considered.
If I could, I might add that this move would only be temporary in nature because we are going to attempt, at least within this term, to create our own new space, either by retrofitting this entire building or moving next to it and doing another building or doing some combination of a building with a courthouse. And we've got to decide whether we want to put the money that it's going to take to fix this building, whether we want to do that. $400,000 just for the roof is going to be a lot of money that could go towards a real building for us at some point in time that would be, this building's almost 50 years old.
Councilor Watts.
So for me to make a proper decision, is temporary to me is 3 months. But then it sounded like 4 years. That's a big difference, and that's wetlands behind us. That was what the issue were that we faced when designing, doing anything with this existing structure other than just going to a different location. So just to refresh memories, I think that was some of the issues. Thank you.
Thank you. Ms. Bird.
Yes, Mr. Chairman, the cost, the $400,000 seems a little bit extreme, first of all, to roof this facility. And second, the council chambers would be good, but that place is really not conducive for business to conduct committee meetings. And I agree with Councilman Watts here about the separation. I think we need to look at some options, 1, 2, and 3. If we were to be temporarily removed from here, what's the time frame? What are we talking about?
Well, what I would say is that, a decision probably, I would recommend that a decision not be made today, okay?
Sure.
But what I would recommend is that an in-depth study as to the cost of building a new building, retrofitting this, what your space cost is going to be on here. But Speaker is correct. Something has to be done. I mean, this is not workable anymore. But obviously, what is to be done is the purview of this body. What I have handed out is a thought, a recommendation that obviously I don't want to give up my office. You need to come see my office. It's pretty. I don't want to have to move. But if obviously I hold the legislative branch in the highest regard, and you all will do get what you need and what you want. So in that regard, if I am to vacate my space, we're going to need at least half of it. So this is a recommendation. It's a thought. It's putting the ball in play, so to speak. So I would review it. I would talk with Mr. Evans to calculate the IDC costs, the space costs, and I intend on having a meeting in the very near future with the principal chief, the speaker, and the chief justice of the Supreme Court to get it in focus as to what the needs are of the three branches as to space. And so we're getting the ball in play. Temporary can be 3 months, it can be 3 years too. So, but that is a decision that you all will make.
Anything else, Councilman Keenan?
Thank you, Mr. Chair. My comments are along the same vein, but I would ask this body to consider the judicial branch. I think they need the space possibly more for other reasons. So if this, maybe just if you entertain this one idea is to put the judicial branch with the AG's office and then maybe staff here while they're working on this building, if that comes up at that time. Thank you, Mr. Chair.
Let's see. Councilman Ford?
Myself, I don't like the separation of powers at all. I like the separation of powers. I don't like moving to Number two is before we do anything, I would like to see bids on this bill and fix the roof. I don't think we're run into what as much as you think you're going to do. Number three, I'd like to see a date set that this building needs to be finished off the bids. Right now, we put out a few little trash cans and catch water, but I don't think we need to think about moving across to the other building right now. I think we need to hone in on fixing this building and fixing it at a price that it can be fixed and set a date that it will be fixed and go from there. I don't think it's going to take them 3 years to fix this building. I think it might take a month. And maybe we'll have to switch our meeting from here to somewhere else at that time. But I think we need to back off and look at this and see what's going on. And another thing is, I don't think anyone should ask the administration over there if they want this body to move over there. And if they do, then I think they better reconsider, because you got 17 people walking halls over there on a daily basis. They may not like us over there walking halls on a daily basis. I know they're not going to like me, because it's like putting the fox in-house. But anyway, I think we need to just back off here, get us bids, float us bids, see what we've got here, and what needs to be fixed, how long it's going to take us to fix it, and get some points to this, and find out what's happening. I don't think just jumping up and moving over there and saying, we need to go in this building and we'll come back over here for a long time. That shouldn't be right. We should just have about a month at the most. Someone should come in here and fix this building in a month. I think that's ridiculous. Thank you, sir.
You need him to yield some time to respond.
I just need direction. Is that a motion?
I'll make a motion.
Okay. I just need direction which way we're going to go.
I don't think about this.
What's the motion? I'm sorry. To get
bids and put a time frame on the bids.
Councilor, would you consider modifying your motion to get bids, time frame on a bid, and just for the sake of thoroughness, get the cost estimates of over there, just so we can have all the information. Make it a very comprehensive motion is my suggestion.
Okay.
Cost bids over there.
Yeah, to move over there, so we have all the information. Well, I understand that, but we'll have it in front of us, Councilman.
Okay,
All right,
yeah.
all right, the accept is, okay, okay, all minds clear on the motion, all those in favor say aye.
Aye.
All opposed, same sign.
Now, let me make sure that I understand what you all want done in the next month. We'll get bids on what it takes to repair this building and the time frame that it will take to repair this building.
Repair the roof.
Repair the roof. Y'all don't want anything done back there in these offices back here in the back that's had some water damage. Y'all are the ones in those offices, so it doesn't,
Close those buttons, keep holding water, we're okay.
yeah. So go ahead and test for the mold. And is there anything else that you all want me to include in, when we get this bid through, yes, Lee?
Could we see how much it would cost for the judicial branch to move over there, or if they even wanted to?
Well, that would really be between the judicial branch and admin. It's really not a call for us to have anything to do with.
I mean, while we're getting costs, X amount of people moving over there, which would be less than this body.
I would be very hesitant to do anything at all with the judicial branch.
I don't think we should get involved in their situation.
The space per cost is what it is. I mean, we can calculate, what this situation entails. But as to an estimate as to the repair of the building, I know we have contractors here and people who know construction. I would get the estimate of what it would take to make this building feasible. I know there's wiring issues. I know there's possible mold issues. There's the plumbing issues. Obviously, the roof has to be totally replaced. So, and as you get that estimate, obviously you can check off what you want to, what you want done and what you don't. But if you're going to rip the roof off this thing, you might as well take care of all the rest of the problems too.
Are you now clear on what?
I believe I am.
Okay. Councilman Fraley,
Mine goes back to your sponsorship of the independent information technology. If the body did want to move over there, it'd be more conducive to what you want to do here. Would you want to include that in your bid also?
Provided it doesn't slow down the process of getting the building. I don't guess it would, but if we can do that, Madam Speaker.
Could I respond?
Certainly.
I believe we could maybe get the bid included and then separated, and I think we could have that in a month too. I'll do my very best to do both 1 and 2.
We've taken action on this item, but this is a discussion item, and I have Councilor Watkins and Councilor Lay still in the queue. Councilor Watkins.
I'd like to make a recommendation on the bidding process that we frame the roof like a 412 pitch.
I think it was going to have pitch. I think that was part of the situation.
Instead of going back over the tar, actually frame a roof up there and sheet it and just put shingles on it.
Actually, may I respond?
Yes.
Actually, it was my understanding that they couldn't tar it again, that it's going to have to, it has to have a pitch on it this time.
Yeah, the engineering report came back and said the structural integrity of what's up here now can't bear any more load on it.
Okay, so we can't frame it.
Well, but you're going to have to remove the units off the top. The HVAC units have to be removed and reduct off the side of the building, and that'll remove a lot of weight, most of the weight. But then probably a lot of the tar, the flat roof component that's on top of the joists, a lot of that will probably be removed. It's in there's where most of our problems lie anyway, is on that flat part of the roof. I suspect you'd want to remove that anyway because it doesn't leak when it's raining, but 4 or 5 days when the sun's shining, and it'll come in like a flood. So there's obviously expansion efforts up there that's going on during warmer temperatures that's causing all the water that it's capturing during rains to just come into the building. One of the comment on the electrical side and wiring of the building, it was reported to us a couple of months ago when they did an inspection of this building. We've been out of code for several years on the wiring, and the wire actually that's inside of this building is starting to create somewhat of concern because of the age of it. and apparently some of the materials used 45, 50 years ago. I'm not exactly sure. I can get more information for you, but the wiring, the compliance on the code, structural code here, is something you might want to take a look at when you go obtaining all these other bids.
Thank you. Well, along the lines of what Doug has just mentioned, and I'm going to defer to probably Councilor Snell or Anglin, but when you jerk the roof off this building, you're going to have to totally rehab this whole building. Wiring, walls, asbestos, lead, mold, you name it. You're going to have to build us a whole new building. That estimate for roof, that $400,000 is not even going to get us in the ballpark. But I'd like to defer to Councilman Snell. Tell me whether I'm right or not.
You're right, because everything painted up, product could change. The wiring, electricity, you could have even more problem with it. This one's been leaking. It's a major job.
Thank you. Councilor Gordon.
Oh, thank you. The way this conversation is going, I was thinking about not putting a lot of funding into this building, maybe fixing the roof. And then we was talking about trying to build a new facility and put that money into the facility. If we're talking about $1 million repairing this bulldozer sucker down and build us a new building. That's what we're going to do. And that will take less time than what we're talking about repairing this building. Won't it?
This is like repairing an old house.
Right.
Councilor, yield to the speaker.
Yes,
When I first started visiting with the space people, I kind of thought this was where the conversation was going to go, that you all really liked this corner. My suggestion when we were talking about it was go right next door in the parking lot, build what building we need to build there, then come back in here and gut this building and use this as our meeting area, and use the area over there as our offices. It wouldn't have involved any of the land back behind. It simply would have took in the parking area. And if it comes out that it wasn't a salvageable deal, we could have moved into the new building which would have been right next to this one, and taken this out and used it as a parking lot. I felt like you all were going to tell me, and I would like to ask for a vote if everybody wants to remain on this corner. I want to know how many people want to stay here. And if you want to stay here, then I'm going to go back and talk to the space people and say, look, let's go back to the first option, make it very basic. We want to stay here on this corner. I just need to know.
I guess I would refresh my own memory here. We have a motion on the floor, Councilman Thornton's motion, which was to go out and get this information. That's the motion on the floor at the moment. More discussion on that. Councilor Conway.
I don't know that I'm ready to take a vote on anything. I'm not, because I don't have enough information. And we've already spent money on architectural drawings for a new council offices and such. So are we totally scrapping that? I mean, I'm okay with that. I'm just, where are we at? Because that sounds...
No, we could have used that, if I could respond back. We could have used that option if we want to go next door. If we want to go just right next to this building, move this way, we could have done that building, very basic, and then come back and we would have scrapped this building, used it as the parking area. And it wouldn't have involved any of this land back here that we want to protect.
Yes,
So I guess for me to feel comfortable making a decision, I would need what that looks like. I didn't go to those meetings. I don't know what that cost is, and I don't know how long it'll take. So, or even if we have, let alone do we have the budget money to do so at this time. But I'm not ready to move. I'll tell you this, I'm not ready to move over and sit next to admin or the AG's office.
Yeah.
Madam Speaker,
If I could just get guidance that you want to stay here, then we work from that objective.
Madam Speaker, I understand this motion to ask you to get a comprehensive batch of information, if you will, that relates in any way to constructing a new building, rehabbing this building. That seems to be what the motion is, pretty liberally construed, however you'd like to. But I think the guidance is to get information on building a new building or rehabbing this one. So is that sufficient?
The one thing we do need to do, if we can make a decision, if we're not going to use the pod, we need to scrap that idea today, because there's other people waiting for space, and Todd needs to know what he needs to do to his part. So if that's scrapped, tell me so today, and I can move with this other idea.
Councilor Thornton, would you entertain a friendly amendment to clarify your motion that this is also a vote that we are not going to the pod? And that
We're not going to the pod. We're going to second until we get a refund.
And would the second agree to that? Councilor Hargis agrees to that. So now it's more clear, I
And
think.
now if we can just take a vote, and then I know the direction I'm supposed to go.
The question been called. All in favor, say aye.
Aye.
All opposed, same sign.
Then the will of the body, I'll carry forward, and we'll try to get her done. Thank you.
Thank you, Mr. All right, we are now at new business item 4, I believe. No, old business item, old business item 3. I'll get there. Oh, this is Councilman Lay. Councilman Lay, the discussion item tabled from last month.
Yes, sir, with your permission, I'd like to make a motion to table this.
Want to table to the next month, Councilman?
Second.
All right, a motion and a second. All those in favor say aye.
Aye.
All opposed, same sign. Thank you, Councilman. All right, new business item, old business item number 4, rather. Councilor Fraley.
Mr. Chair, I'm assuming we've all received this memo and chart of changes, so based on all the information that's provided by Ms. Odell, I move for approval.
Second.
Motion and second. Any discussion? Councilor Lay?
You say we have some changes here? Just got that.
Did you get a copy?
Probably.
There are no new changes. The changes have been the ones that have been in your previous book and this book.
Ms. Odell just organized them a little better.
Okay, there's no changes, then I guess I have a question about, Meredith, does this, if I may, go along kind of with the state law and the rules, is that what you've done here? I noticed
Some of the
5
changes.
business days for somebody to comply for income. If they can't get it in 5, then what do they do?
Mr. Dale. Wrong.
I helped the child support office draft it, so, what's your question?
Okay, down on the bottom of page 1, it says, child support collected, what have you, proof of income within 5 business days of court order. Is that going along with state rule and law here? It seems awfully quick. I don't think most of us could get our income like that.
Right.
I could.
What section is that? Can you tell me which section?
Section 4.
Oh, okay, I see what you're saying. Okay. It was already 5. All we did was add business days versus just 5 days. So before it was already 5, and all we did was just put in business days to give them more if it's a weekend or anything like that. So the law already had 5 days.
Do we need to stay in comply, keep this similar to state law to comply?
Not necessarily. No, I mean, a lot of this is adopting the Oklahoma changes that recently were enacted, but the law can be whatever this body wants it to be as far as that goes. Now, there are some federal regs that have to be followed, but other than that, no, we do not have to follow Oklahoma law. And a lot of this does not follow Oklahoma law. And on that chart, it says where Oklahoma law is followed and where that is not. the memo and the chart I gave you, there's a section in there that tells you if it follows Oklahoma law or not, if it changes.
Councilman, it is a loose thing that's passed out, loose, not
Okay, one thing I said, I'd like to see that 5 days increase somewhat, just to give somebody a reasonable chance to respond before a court order comes to them. And I don't know how to make a motion to do that, or I wonder if you have any idea what that would look like.
If you guys want to change it, you can change it to however long you want to give them to get that information.
I'd like to make a friendly amendment to change the 5 to 10 business days.
Councilman, could you direct me to where you're talking about? I apologize.
Section 500, subsection 1.
I'll second this motion.
And it was to extend it to what, Councilman?
From 5 to 10 business days.
Okay, that was a friendly amendment, so who made the motion? Meredith made the, do you accept that friendly amendment? Okay, and the second accepts? Who's the second? Councilor Garber accepts, okay.
There was like 3 of us that seconded it, so I didn't know who you got.
Okay. All right, so we've had that. Thank you, Councilman. Anything else,
Well,
Councilman?
if it's me, I don't accept. I want to talk about it first. I mean, no, but...
Okay, you were not the second, Councilor, so we have the friendly amendment
No,
second.
the Shelley, the recording secretary, has it as...
You have hers here?
She's the one.
That's fine, that's fine.
I have a hard time hearing.
That's
you,
fine.
so bear with me.
I thought you said Councilman Garber. All right, so if you want to, you need to make that in the form of a motion, and then we'll go into discussion on it, and then Councilor Cowan Watts would like to discuss that. So you making that in the form of a motion?
I am, and I would like to make that in form of a motion to change that 5 to 10, and
I'll second that.
Second, all right. And we'll move into discussion. Councilor Cowan Watts?
Thank you, Mr. Sheriff. Okay, I don't know how we came up with 5, but we've been administering that way, and we're going to give them potentially another 2 days, is what that effectively does. But on the side of what probably is more than likely a single mom, first of all, thank you for all this work. I know it's probably considerable, but I have gotten really positive, and I'm sure there's exceptions, but I've gotten very positive feedback from both the families that are the recipient of the needed child support and actually the people that were in arrears on child support, because you work with those folks to kind of get everybody lifted up.
Right.
So I don't necessarily see the 5 days as an issue, and I may still support moving to 10, but I want to hear from you the side of the family that needs that money, that doesn't give you any leverage to make sure they get that money, maybe pay a mortgage or rent or utility bills. Am I looking at this I mean, help me out
I
and
can
understand
say
what the
typically,
impact.
whenever we have an order, whenever we are requesting that the parties provide income, it's continued 30 days. So they've got a lot more than 5 days to provide it. So we don't
Okay.
usually ever stick to that 5 days and say, you didn't do it in 5 days, we're holding you in contempt. I mean, it's typically, it's continued 30 days to give them time to provide that income.
So may I ask it a different way then? So if we change it from 5 to 10, does that impact your ability to get that work done or impact the families that need the money?
It doesn't necessarily impact, it could impact the time frame that we are able to get a case docketed to be heard for an obligation to be set, which could extend the time, which, I mean, it could affect how quickly we get things set on the docket, depending on how...
Yeah, this section is talking about where the court orders us to compute it. Typically, that's done before we ever get to court. So that's in a case where we get to court, they haven't provided the incomes, and the court's saying, now provide it. And typically, we never even get to that point because they've already given us the income before we ever get to court.
Okay, so may I, so if the issue is that we want to make sure and give people adequate time to respond, you're already doing that.
Right. Yes.
So effectively, it really doesn't do anything to extend it either.
Right. Either way, they're going to have time because we don't contempt them for not doing it within 5 days, and usually the order gives them longer than that anyway.
Okay.
This is just relating to the office and what you can do.
I'll lean back to the sponsor then. Can I defer some time to her? Do you have any feedback on one way or another? Or?
I think by his suggestion of 10 days, that tells the judge that So they're given an ample time to be less likely to continue.
Okay, okay, very good. Thank you, thank you, thank you.
Councilor Keenan?
Thank you, Mr. Chair. The way I read this, it's not you're not asking for a income tax return. You're just is that right? Or you're just asking for a check stub?
It can.
It can include that.
If they do not have a check stub, some people don't work in that way. They don't have constant check stubs, so they have to provide taxes. It's usually either or.
Okay.
But usually it's the past year's income taxes. It's not the current, so they already have it done.
Right. And your experience, when most people will comply within 5 or?
Yes, usually they do.
If they're ordered to do it, they comply. But they usually have longer than 5 days to do it. So
They already have longer than 5 days already?
Yes.
That's what
Mm-hmm.
Okay. Thank you. Thank you, Mr. Chairman.
Any further discussion on the motion? All right, so the motion is to change 5 to 10. All lines clear? All those in favor say aye.
Aye.
All opposed, same sign. Thank you, Councilman Lane.
Thank you.
All right. Any
Call
further
for question.
Call for the question.
No, I will retract.
Caught me off guard.
Last week, go ahead.
I just wanted to ask Cherokee a question. Somewhere in here, are we at some point going to be able to write something that takes into consideration what we've talked about, the possibility that there be some sort of debt validation procedure if
We could definitely look into that.
I would like for you all to, you know the specific
Yes,
instance I'm
yes.
talking about. They say they've got all their, or most of their receipts, but the state, which you derive your money, or derive your information from, is saying, oh, no, they owe this. I would like for them to be able to request and receive the months that we're telling them that they are delinquent, so they can go back and have a little bit of time to go back and put a receipt with that month. And I used to work child support, used to do a lot of it over, in fact, before you all existed, I set the child support office up in this area, and that was a weakness then, and it's a weakness now, that we just assume that people that we're saying owe child support are lying, that they really do owe the child support. Well, sometimes I've found in the years that I worked child support, some of them were telling the truth. And they really did have receipts, and I want to give them a benefit of the doubt. And we've talked about this problem.
Right, and I know in our policy, we are trying to make sure that validation does occur. We want to give every client an opportunity to bring forth their receipts and sit down and reach an accurate computation, because that's always in the best interest of the child. We want to make sure that we set fair computations because we want the child to receive some payment. And we found that if we establish a fair computation, then it works better on both sides. So that is our goal in our office.
If we could, at some point in the future, I know we can't today, but at some point in the future, Kara, if you would have that worked up through the AG's office so that, I call it debt validation because that's what we talk about when we sue someone for a debt and they say, well, I don't owe that. Well, they have 30 days to ask us to get the paperwork to show that they do owe it. Well, it's the same thing here. Let's generate our report and let's sit down and go over the report with them so that they understand what months they were actually delinquent. Let's give them a small period of time to go forth and get their proof to bring back to us before we ever go to the courthouse. And if you all could some way work that in on the next amendment, I would certainly appreciate it. And we want to be fair to both sides. I want to see the children get their money, but then I don't want to see people paying 2 or 3 times just simply because they couldn't figure out where they were delinquent at. And there really, truly is some cases of that nature.
That makes sense. And we'll definitely consult and see what we can look at and consider. Thank you.
Thank you, Ms. Speaker. Entertain a call for the question. Question been called. All those in favor say aye. Aye. All opposed, same sign. Thank you.
Thank you very much.
Good job.
We'll now move to old business item number 5, which is legislation that I have sponsored. Is anyone from the Cherokee Phoenix here today? That is not in a reporting capacity. Well, this legislation was tabled last month. This is an act shielding journalists from disclosing certain information in government proceeding. Journalism shield acts are fairly common throughout the country. I think in 40 states, including the state of Oklahoma, they exist. And in short, what it would do is protect a journalist from having to divulge her sources if she's hauled into court in a civil or criminal proceeding. There's some exceptions. And there is some exceptions if the court simply cannot find the information anywhere else, that they have to have the journalist divulge it. It's something that the Phoenix thought was important. I thought it was a good idea. So I would entertain motions for its approval when we get into discussion.
Second.
Second by Councilor Crown-Watts, moved by Councilor Fishing-Hahn. So that's the long and the short of it. And this mirrors the law that's on the books in the state of Oklahoma. It would give some rights to journalists in Cherokee Nation courts that they don't currently enjoy. One issue that came up was the Phoenix was subpoenaed in some recent employment proceedings in Cherokee Nation. I don't think they were actually called as a witness, but I think it occurred to the Phoenix that what are we being called into this proceeding for? Are we going to have to divulge confidential sources? And part of good journalism is the ability to talk to confidential sources and develop reporting on that basis. So that's the purpose of this. I certainly urge its approval, but I think it's a point that is worthy of debate. Yes, Madam Speaker.
I just want to make sure, because I believe you're the author, or the sponsor, that we're protecting them from everything but a defamation suit, right?
Correct.
If there is a defamation suit, which is a suit where someone believes a falsehood has been told about them out in the public place, and if that information was used in a newspaper article, then they cannot use this law to shield them from exposing who told them that information.
That is true. And specifically at Part 2 of Section 5, exempts that class of litigation from the shield that this law protects. But yes, Councilor.
And as long as that's covered, I don't mind voting for this. I just want to make sure that we understand that there are times when they shouldn't be shielded from giving that information or giving that source, especially if it was a lie that was told about someone. And I think you've covered that.
Okay.
Thank you.
All right. Any further discussion? Then I'd entertain a call for the question. Question's been called. All those in favor say aye. Aye. All opposed, same sign. Well, this was an act.
Yeah.
Roll call. My apologies. All right. Let's return to the vote. All right. All those in favor, clerk will call the roll. What we do by acclamation? Yeah, let's by acclamation. All those in favor say aye. Aye. All opposed, same sign. All right. Very good. Very good. New business 4. We are now on new business item number 4. Councilman Watkins, if you're one of the sponsors of this resolution, can you introduce that to us?
This is a resolution to encourage and endorse and promote the alternative energy initiative developed by Brian Barlow. Motion.
I would second that.
All right, we have a motion and a second. Any discussion?
I might enlighten the body as to what Mr. Barlow's project is. He is a member of our youth council. He is a senior at California High School, and for a number of years he has been going about the process of encouraging the California public school system to implement green activities within the school system. couple of years, he has encouraged the community to assist in a project where they would put solar panels on the science building. He's also president of the science club. They would put solar panels on the science building to explore whether that would be a money-saving device as well as leaving less of a footprint in the community for later generations. He was featured actually in today's Telephone newspaper. He and his project were a feature story in the daily press, and I believe I have it on my desk. He's an outstanding young individual. One of many resolutions that I hope that we can bring over the next 4 years where we honor our young individuals that have taken on projects that normally we would see coming from much older people. I'm very proud of this young man because he has really turned out to be a good Cherokee Nation representative. And with that, I would ask that you all support this resolution. Thank you.
Any further discussion of the resolution? Call for the question. All right, question's been called. All those in favor say aye. Aye. All opposed, same sign. All right, we now move to new business item number 5. It's an act amending the General Corporation Act. And Madam Speaker, you're the sponsor. Will you take this?
If you all will recall, a couple of months back, we put 8 people on as the advisory board on C&B, and this is a house cleaning activity. We found this act which called for only 6, and since we had, during the time that we were naming advisory members, named 8, we thought we should clean this act up, and I put that in the form of a motion.
And I second it with the friendly. I want to add a section C under 4 to read the council selection of advisory board members of February 2012 as a part.
Accept that.
Yes, I would.
All right, with that friendly amendment, any discussion? Discussion. This is an act. Call the roll.
Frankie Hardy? Chet Hopkins Jr.?
Yes.
China Blair Jordan?
Yes.
Lee Keener?
No.
Dick Lay?
Yes.
Curtis Snell?
Yes.
David Thornton?
Yes.
David Watkins?
Yes.
Eric Allen Watt?
No.
Bill England?
No.
Jack Baker?
No.
Joe Byrd?
Yes.
Julia Cope?
No.
Jody Fishenkoff?
Yes.
Meredith Fraley?
No.
Janelle Fulbright?
Yes.
Don Garvin?
No.
Ten yes and 7 no.
All right, the act passes. We'll move on to new business item number 6. This is an act amending the Emergency Assistance and Community Support Projects Act. I have a new version of this that was passed out by Gail a few moments ago, so it's not the one in your book. There's been some change to it. I'll direct your attention to that. And to get into discussion, I entertain a motion to approve.
How much motion?
Second.
No, please. Change it. You want to change it?
Do you want to do something beyond what we've done here? Okay. And just for some brief introductory remarks, the community assistance, which we approve every month, we've been doing for a while. Researching the law, it looks like when we went to the donations and contributions, which we did for a few years under the prior administration, or perhaps just 1 year, we actually repealed a section that actually gave authority to that community assistance, and that was important because years ago there was a judicial appeals tribunal decision that said that we had to have some underlying legislative authority to actually do this community assistance, give the program some structure. So that's what the original Emergency Assistance and Community Supports Act did. We repealed the relevant sections when we did donations and contributions, which was itself a different law, which involved a different procedure. We have been, since we've been calling the money that we approve community assistance, we've, in my view, been arguably operating in kind of a limbo land where there's no real legal authority that tells us how to do this, and I feel like we should have this. I know we've got the Attorney General here. He knows some background on the original legislation, and our Attorney, Matt Barker Harold, also has some knowledge on that subject. So if they have any comments, I'd ask them to weigh in. But Councilman Thornton has agreed to co-sponsor the amended version, which we've passed out. And Councilor Thornton, did you have
I have an addition to it, but everyone agrees. And what I'd like to do is add townships and cities if there are 51% Cherokees involved in the grant.
And Councilman Thornton, you and I talked offline, and in Section 5, I put county governments or municipal governments for activities which substantially impact the health, welfare, or education. And if you yield back to me, I might go through some of the parts of this that, such as...
I'll yield back to you.
All right. So, councilors, the first section in definitions, it defines community organization broadly, so that it's really any organization that's based in the 14 counties. Now, there's a limiting provision in Section 5, which I'll get to in a moment. It also defines school, which is, again, pretty broadly defined. The third was hardship, something that Councilor Thornton brought up. There are times when some of our citizens have hardships that there's just no program that can timely get them assistance, and Councilor Thornton can give us several examples if need be. But those come up, and I think under the original community assistance, we actually helped those. That was before my time on the council, and then somewhere along the way, we were more restricted. Section 5 gets into more of the substance, and one of the things I run into in my neck of the woods is I may have a good community organization that helps Cherokees in Bonita, for example, but it may not be 51% Cherokee. As you get to the outlying areas where the Cherokee population is less dense, you find that, but you still find Cherokees that benefit from these organizations. And so I think really the way we've run the program was we've helped some of these organizations, but I'd like to make sure we have the legal authority to do it, because I think we say 51%, but there's a lot of organizations out there, including in my neck of the woods, that help Cherokees, but they may not technically fall into the 51%. Section 5, Part 1B adds some new language. Councilor Thornton was concerned that in his neck of the woods, sometimes some of the smaller towns and even some of the counties have programs within which impact Cherokees, and they may need some assistance. Section 5 is for the purpose of addressing hardship. Again, I know that's broadly defined, and it's sort of, it is what it is, it seems to me, and I think it seems to Councilor Thornton that if it comes to this body and it's a hardship, and a councilor says, this is a special case, no program can address this issue, if we as a body approve this in the context of community assistance, I think that gives it the sort of the stamp of approval that it was a significant hardship. Otherwise, it would not have passed this body. So, in a nutshell, that's it. I tried to adhere to what I think is our practice now. But, you know, this is kind of a work in progress. I just wanted to introduce it because I do think we need some legal authority. Councilor Coates, I had you next.
I wonder if to make a motion, I'm sorry. Okay, if Councilor Thornton would entertain a friendly amendment to Section 4, Number 1, operating in the 14-county Cherokee Nation jurisdictional area. In the years that we've had community assistance allocated by councilors in the past, both Councilor Baker and I, as well as Councilor Keene before that, I think have given community assistance to our at-large satellite organizations as well. And this would essentially restrict us from being able to do that, and I wondered if you would entertain friendly to remove that, or perhaps to define it better, or those at-large satellite organizations that are officially affiliated with the Cherokee Nation.
Councilor. Yeah, I know you directed it to him. actually did not intend for that to be, to cut out any of the past funding. I wanted to sort of continue the program. So I wonder if your motion is just to strike the "and which is based in or operating in the 14-county jurisdiction." If we just struck that language, would that be sufficient?
I would be okay with that as long as it didn't, I don't know what others feel about it. I don't suppose anybody wants to be giving money outside of their own districts, I wouldn't imagine, but that would be the only.
I'm sorry, yes. Go ahead.
I do give money outside of
Do you? Okay.
But yes, I'll take that.
All right, it's been accepted by the mover. Who seconded?
Who seconded?
Councilor Hargis, do you accept that? And just to speak a little further than that, there could be an organization that's based outside the 14 counties but helps folks right inside. And it's similar to the folks out in California who are outside the 14 counties but help Cherokee. So my goal is just to kind of continue the status quo as far as funding. Copy Bill's a good example, Chief. I had Councilor Walker still.
Just some discussion on this is something similar to this is our backpack program that we got going on in our public schools, and that we give funding to organizations that put these packets together. And one of my biggest concerns, I mean, these are good programs, but the biggest concern is the checks and balances of the money going to the Cherokee constituents, because we're on an honor system by giving this money out to these organizations, and I would like to see some fall through on the administration side, is that money in these funds do go to Cherokee constituents.
Would you yield this?
Yes.
And I appreciate that, Councilman. When you're talking about the backpack program, that happens to be something that's been a line item in a couple of budgets to which we've really attached no legislative structure, and probably we should. This goes to, it does go to funding to organizations and schools. Usually the amounts are smaller than the backpack program, which was on the order of, I don't know, $20,000 to $50,000. Usually, and again, if this continues what we consider to be the community assistance program, usually we get requests that are very specific, and the money is generally, in my feeling, spent for those specific projects. Now, backpack program, I think, is a bit different, and we need to address that. I would suggest that it's outside the context of this legislation.
Okay.
Anything else?
Thank you. I had several questions. I'm afraid they're directed towards you to answer, I think, so.
That's fine.
Just to clarify, on section 4.1, so what was the actual language? Because not just satellite groups, which I do think should have that money, but there's contiguous areas, like especially Tulsa, where they serve a large number of Cherokees, but they may actually reside in either Creek Nation or Osage Nation, for example, and we've given to them in the past. Would that be included in that language? Because I never heard, I didn't.
Well, it was accepted, and that was
Okay.
striking the sentence that was limiting. So
Okay.
in a sense, it's unlimited at this point.
So then I have two more questions, and then you can probably answer. So one question is, how would this be different than maybe what we've experienced in the past? And then under the hardships, which we had not funded for some time, so for transparency to the Cherokee people, how are we going to, if people question whether or not that was a hardship or not, which they have a right to do, how would we then protect those? I mean, where's the balance? How is that information going to be made publicly available? What is that like? And then how is this whole policy, what would be different?
Well, as to how it would be different, I don't think it would really be different than how it's been operating. The difference is that we'd have actually something underlying it to rely on. We could go back to it and say this is compliance or it's non-compliance.
Thank you, by the way.
In terms of the transparency, and I hate to push this all off on Madam Speaker, but there is a section in here that authorizes the Speaker to develop some policies. So, if we are cutting checks for extraordinary hardship cases, and mind you, that would be something that, just like every other piece of community assistance, comes before this body. Now, we often vote on it in a rather pro forma manner, although I think we all look at the items beforehand, and if there's a red flag, we ask about it. I suspect if there's a hardship that's brought before this committee, it will get perhaps more scrutiny than, say, something to the local school's Indian education program. And then following through on that, when the check is cut, I would imagine there would be some requirement to produce receipts, and the speakers could certainly develop those policies pursuant to one section in this act, which is more specifically at Section 5 to G. And so I think we all want transparency, but we all recognize that the way this program works, the reason it's wonderful is that we are able to act quickly to meet needs that otherwise don't get met. So we have to strike a balance between perhaps overloading the legislation with reporting requirements and deferring to the speaker to develop some common sense policies that can be out there. And we can even do a records retention policy in which we retain these receipts for a period of time. I mean, the speaker could decide that we're going to keep these for the following fiscal year after they were received, so that if anyone wants to scrutinize it, they could go back and look at the record. So I hope that's responsive to your question, Councilor, but I do think
It is. Thank you, Mr. Chairman, and thank you for the work.
Certainly. Any other questions, Councilor Baker?
Yes, under item G, it does not have the hardship cases listed yet. I would ask for a friendly amendment to add the hardship cases also under section 5, item G.
Sure. Including those related to accounting, dispersed funds by community organizations, schools,
or hardship.
And let's just put them all, let's say, because there's also county and municipal governments and hardships, so that's thorough across the board. And that's a friendly amendment. Councilor Porter, you accept that, and Councilor Hargis, you accept. All right, thank you, Councilor Baker. Sure. Anything further? All right, Councilor Hargis.
I'd like to add that.
Councilor Hargis wants to be added as a sponsor along with Councilor Porter and myself. All right. Does anyone? All right. We have Councilor Anglin, Councilor Fishing Hawk, Madam Speaker, Councilor Fulbright. Okay. Councilor Hargis was added. Councilor Walking Stick, Councilor Lake, Councilor Calhoun. I think we're to the point where we're asking if anyone does not want to sponsor this. I hate to say that, if anyone does not want to sponsor. Does everyone want to sponsor this? Show of hands. Okay. Did you note the exceptions? Everyone is at that. Everyone is at that. All right, thank you. All right, entertain a call for the question. All right. This is an act. Roll call.
Kurt Snell,
Yes.
David Gordon,
Yes.
Dave Washington,
Yes.
Kara Calhoun,
Yes.
Bill England,
Yes.
Jack Baker,
Yes.
Joe Byrd,
Yes.
Julia Ketz,
Yes.
Jody Fishenhawk,
Yes.
Meredith Braley,
Yes.
Janelle Fulbright, Don Garvin,
Yes.
Frankie Hargis,
Yes.
Chuck Hoskin Jr.,
Yes.
China Wordsworth,
Yes.
Lee Keener,
Yes.
Dick Blake.
Yes.
17 yes, 0 no.
Move on to new business item 7. This is an act that I've sponsored, an act establishing the Cherokee Medal of Friendship. Entertain a motion to approve.
I'll make a motion to approve with, I have asked Shelley to add my name onto it. Am I on the handout one? Okay.
Oh, that's right. Yeah, and we actually have a revised, did we have this handout? Okay, and my apologies, we have a handout that revises it, and the motion was to approve by Councilor Fishing Hawk, with adding her, and Tyne as a co-sponsor, and on the revised version, and Councilor Hargis as a co-sponsor. Do we have a second? We have a second by Councilor Hargis. Does everyone have the copy in front of them? I think we have it in, yes. The purpose of this act is to establish a new, or what I consider to be a new award, which is to award those non-citizens who contribute in some very significant way to the Cherokee people, our culture, teaching our history, et cetera. It would place a limitation on the number of awards. It would provide some structure as to how awardees are selected, and in this case, our Section 3 1A would require the principal chief, or empower the principal chief, rather, to nominate individuals that come before the council, and then the council would act on that. There is in Section 3, 1A, it does set forth that Willard Stone would be would receive the first award posthumously based on his contribution. So this act would actually designate the very first awardee. There would be annual limitations, no more than 2 per year. There are some additional benefits. The most significant of which is an exemption from Legislative Act 0107 as to the sale of any work of art or literature to the Cherokee Nation or any of its entities. Presently, if you're not a Native American and you're producing artwork, it's not to be purchased under that legislative act. That's my understanding. This would provide an exemption for that awardee and his estate. And in the version that's passed out, there's actually a limitation. I certainly don't want to imply that this is an award that should be used to demonstrate citizenship or establish citizenship. So in the revised version, it has a new Section G, which says just that. It's not to award any type of actual honorary citizenship, just so there's no misunderstanding about that. I did have some discussions with Councilor Jack Baker about efforts that are ongoing to do this. And Councilor Baker, would you speak to this?
With the Rehabilitation of the Boise District Heritage Association actually presented a proposal to us, which we approved, to create a friendship award, which we're going to work with the Cherokee Nation. And in that, we were going to have a dinner, honoring dinner for 5 to 7 people, and every other year. But in addition to that, a couple of years ago, I asked this body to issue the same type of designating someone as a friend of the Cherokees. Reverend Charles O. Walker in Georgia, who done considerable work for the Cherokee people in identifying Cherokee home sites and written several books. And we did that. So I would like for us to continue to be able to do that. And this act would limit our being able to do that. And also, in reference to Willard Stone, there was either an act or resolution under Roland Manthor's administration when the Indian Arts and Crafts Act first came to being, and he was declared a Cherokee artist at that time. And this may actually detract from that.
Okay. And I appreciate that, Councilman.
And I would like to make a motion to table until we...
Would you allow, let me yield to Councilor Conway, because I actually want to have some explanation about this earlier legislation. And the reason is because if it doesn't clearly authorize Mr. Stone's estate to sell to the Cherokee Nation, then that doesn't get to one of my goals, which is a goal I need to get to with some dispatch. So, Councilor Conway, can you speak to that?
Okay, I'm going to try to get to, so first of all, I think that we need to be doing stuff like this. So I appreciate the work, but I think it's mixing numbers of things, and we need to look at it differently would be if I had to vote on it today, I couldn't vote for it. So back in January, February of 1991, there's resolution number 1591, which actually recognizes Willard Stone as a Cherokee Indian artisan, which is allowed under the federal act. If we need to do something, it would be to amend our Truth in Advertising Act for the Cherokee Nation. But from a federal perspective outside the Cherokee Nation, he has been authorized, he and Burt Seaborn. And I appreciate Joe Burt, because I have the meeting minutes as well. I appreciate Councilman Byrd's remarks at that time. I concur still with what you said back then. And I mean, it's all on Legistar, both these are. But he is authorized to sell right now as an Indian artist. Now, when it comes to us, that's a different deal, but from what I understood, we have a lot of its inventory. So I don't know that, are we just not buying it in the gift shops? Is that the issue?
My understanding is that there was a feeling on CNB's side that they could not purchase his art, that they were legally prohibited. And it sounds like the legislation you're talking about from some time ago makes that not true. Makes it, and I would ask the Attorney General.
I would have to look at the Truth in Advertising Act, because it may. I mean, I don't know how you would merge this, because we didn't address this issue. Because it's not just Willard Stone, it's also Burt Seaborn. In how we would marry those two. But what I would ask is that if there is parts of this legislation that you want to keep, we have a lot of other work that needs to be done, and we table it for a month. But on Willard Stones, we could, I don't know if the Attorney General already knows what the opinion would be, or if we need to amend that Truth in Art Act, which would have to be waited till next month too.
Well, this resolution would allow Mr. Stone's estate to sell as an Indian artist, okay, and sell throughout the United States. However, we have passed our truth in advertising law that is specific to the Cherokee Nation. Now, what I would want to do is look at that piece of legislation, because it did say, that it was from members of federally recognized tribes, if I remember correctly, and I can take a look at it real quick. But this would allow him under the Federal Act to sell to any other tribe and go to any art show and be recognized as a Native artist. But we may have passed our act specific to the Cherokee Nation that may have limited that.
And it doesn't confer citizenship either.
No. Mr. Henry, if you look at section 3(1)D on page 2, it exempts them from Legislative Act 0107. It also exempts them from any similar Cherokee Nation statute, policy, rule, or procedure. Now, I understand it's better if we're specific. Couldn't we simply say it exempts them from the Cherokee Truth in Advertisement Act?
Sure.
And quite simply carve out that exception? And so if that's the case, then I'd entertain a friendly amendment to add that language. And Councilor Graham-Watts?
Mr. Chair, that still doesn't address the number of other issues with this.
Well, what are the number of other issues?
There's other friendship acts. There's other friendship type models. If I take just the friendship deal the way I read it, I would not be acknowledging Willard Stone as the first one. There's a number of other people in line. It doesn't. If it's just to address him being able to sell to the deal, then that's a whole different piece of this legislation. It still doesn't. I mean, if we want to make a motion to allow this, recognize and affirm this resolution, and say that it would be exempt, and we as a body take a public vote on it, I think that we could remedy that for right now and be done with it, and then we could bring this back and we could caucus with you to say, what do you want to do with this legislation, and how can we come to agreement?
Councilor, I guess my question is, does that take care of the Truth in Advertising Act today? Because all we're doing is reaffirming.
We make the law.
Well, I understand that's not on the agenda to amend that. And so if you're suggesting that we do that, then I'd be fine with that.
As part of this, I mean, it's around the intent of this act. We can take this act and we can scrap the whole content and make it just that, but it still has to go to full council and be signed by the chief, so we still have that time frame.
That I'm inclined to agree with. Councilor
And I think Ms. Malaya can clarify a little bit, if you don't mind.
Certainly, yeah.
Thank you. The issue at hand here is that the only money that we have available from the business side of things is money that's allocated to procure art from the 1% allocation. If you look at the legislation in the 1% allocation, which is the 0107 legislation, it clearly states that when you set aside the 1% allocation, it can only be used to procure art and or artifacts, whatever, from blue card carrying Cherokee citizens. Now, from the business side of things, that's the only money or pool of money that we have available to purchase said pieces of art. So if you're coming to us and you're asking us to purchase Willard Stone's art, which by the process set forward Cherokee Nation, he is not a blue card carrying citizen, legally, per the way that the law is written, we cannot purchase his pieces of art because he's not a blue card carrying Cherokee citizen. Therefore, the issue that you have here.
Legislative Act 0107 is the roadblock here. Is that correct?
It is. That's what's prohibiting us from purchasing that art because of the way that the money is supposed to be spent.
My primary interest is to make sure we can purchase some art from the estate of Willard Stone because his widow is in need. My secondary objective was to get a medal of friendship so we can start honoring these people. Councilman Baker has advised me that there's already models for doing that. So I'd entertain a motion to strike all language, as Councilman Conlott suggested, to do a specific exemption for Willard Stone. I didn't want to make it about one person necessarily, even though, quite frankly, that's what's brought us to this point today. So if the councilwoman will make that motion, then we can get to that.
So moved, as long as it's both, it probably more than likely has to address both the Truth in Art Act and the 1% set aside.
Okay, we'll add the truth in art, and the substantive language would really be found in D2, and that would be about all the language that would be left in terms of substance, and we would just specify Willard Stone for the purpose of this act. Is that your motion, Councilor?
Yes, and the one that goes to full council should also reference, and I apologize, I gave my document to the AG and we'll email out what I researched to the whole council tomorrow, but it should also reference that old resolution so there's a proper historical record since those.
I agree with that. We can put that in the legislative history. So
We'll second that.
it's been seconded. Moved and seconded. Any further discussion?
Madam Speaker, you may want to just take it to the resource committee and have people legislation ready for the resource committee.
Yeah, I think that's a fine idea. Councilman Camelot,
That's fine.
so we'll table further action on this to the resource committee. Is that what you're suggesting, Diane Barker? Is that what you're suggesting? All right, so we have a motion to table this to the resource committee. We have a second? We have a second. All those in favor say aye.
Aye.
All opposed, same sign. All right. All right, new business item number 8, legislative acts addressing smoke shops. Councilor, there's been a new version passed out. There seems to be the order of the day. That's the purple one. It has the purple revised print on it, Councilors. And this has been revised substantially since the original legislation. I entertain a motion for approval so I can make some additional comments. Motion by Speaker, second by Councilor Pigeonhoff. Councilors, originally this legislation was designed to provide rebate, subsidy, et cetera, to smoke shops. Our smoke shops employ a lot of Cherokees. Our smoke shops generate revenue for the Cherokee Nation. Our smoke shops provide income for some of our Cherokee citizens who own the land. So tobacco I have a personal issue with, but when I think about the revenues that can be brought in and the people that can be put to work and the fact that the tobacco is going to be sold by non-Indians, I think we need to keep this industry going as a way to kind of diversify what we do. They are struggling. Yes.
Before we did that, I'd like to table the first reading.
Well, how about in the nature of a substitute?
Substitute.
All right, so the motion was to substitute these.
Well.
And to table the other two. Okay. So a motion to substitute and to table further action on the others. That's our motion.
Second, can I second that? Are we going to, we're amending the original motion on the floor?
Yeah, we accept that.
With the print on it?
Yes.
I would like to set up a subcommittee to meet within the next month. We will talk about the other issues pertaining to the tobacco retail.
And Speaker, would you consider it as a working group rather than a subcommittee to give us
Working
more
group, that would be
flexibility?
fine.
Okay.
Working group.
Very good. All right, so that's our motion. And just to highlight what the changes were, I looked at the compact, and the compact is law. The compact says what we can do and we can't do because we've agreed to do that. Now, originally, Councilman Thornton and I set up to give some sort of relief to all the smoke shop based on the number of cartons of cigarettes they sold. That was our first approach. looking at the compact, I recall that Tax Commissioner Webston had interpreted it last time as saying you could only rebate to the border shops. There's a specific class of shops in the compact. The compact, by the way, is effective until June of next year. A specific class of smoke shops that are border shops based on their proximity to the border. Right now, I think, Ms. Webston, there's only 5. There's only 5, and so the compact, suffice it to say, said you could only rebate to those. And I asked the Attorney General for an informal opinion on that issue, and he confirmed that. So as much as we, at least where I'm sitting right now, as much as we would like to rebate to all the smoke shops, right now we're thinking we can't, but we haven't given up, haven't we, Mr. Thornton? No, we haven't. We're going to continue to look at
Don't call
this.
it rebates.
We don't call it, we'll call it whatever name we need to get the job done. But, so for the purposes of today's action, we need to give the smoke shop some relief. And so this amended version takes out everything except a reduction in the sales tax of non-tobacco products for licensed smoke shops, not including licensed smoke shops that operate directly through Cherokee Nation or its businesses. So we're talking about the private tobacco retailers that we license that are out there, whether they're border smoke shops or not. They're going to enjoy a reduction in the tax they pay on the sale of non-tobacco items, and that is actually not a very significant form of relief when you look at the numbers. And it also means it's not a very significant impact on our budget. And Doug, you may want to refresh my memory. Well, in fact, Doug has put together a memo. I think it's on the order of about $50,000. Is that what the reduction would?
Going down to 2%, yes.
Going down to 2%, it would cost us $50,000. And we're talking about an industry, again, that employs people, provides income for Cherokees. So with that, motion to substitute this.
I'll make the motion. Substitute this.
All right, we've got the motion to substitute that, and we're also tabling further action on rebates, subsidy, et cetera, to the next month. And to develop work group. Any further discussion, any questions? Councilor Keener?
Thank you, Mr. Chair. I'm wondering if we could reduce that by another 1% and make it 1%, the token sales tax.
Is that offered as a friendly amendment, Mr.
Yes.
Keener?
Yes, it is.
I'll accept.
All right, it's been accepted by the second. All right, and we can have an idea of what that'll cost us. The entire tax brought in under $75,000, so we're talking about.
We'll make it about 12,000.
Mr. Keener, did you have any further
That's all. Thank you.
All right, any further discussion?
One of us over here, I think, I understand that we've got to have some tax, but it doesn't say how much, so 1% would be fine with me. I mean, the trade-off is, we're creating about 400 jobs. And that's certainly a good trade for 75,000 or whatever. We're saving that many jobs. Well, job saved is job created, as far as I'm concerned.
Councilor Watkins?
What percentage of our employees in Cherokee are in smoke shops? Is it a requirement that our Cherokee needs to do?
Anything further, Councilor Watkins?
Not for question.
Call for the question. Question call. This is an act. Roll call. Call the roll.
Julia Coates,
Yes.
Jody Fisher-Hawk,
Yes.
Mary Fraley, Janelle Fulbright,
Yes.
Don Garvin,
Yes.
Frankie Hargis, Chuck Huston Jr.,
Yes.
Shannon Gloria Jordan,
Yes.
Lee Keener,
Yes.
Dick Clay,
Yes.
Curtis Snell,
Yes.
David Thornton,
Yes.
David Watkins.
Yes.
Karen Callan Watts,
Yes.
Jill England,
Yes.
Jack Baker,
Yes.
Joe Burton.
Yes.
17 yes and 0 no.
All right, we're at new business item number 9, Councilor Fisher-Hawk.
I would like to table that till April.
Bless you. All those in favor, say aye.
Aye.
All opposed, same sign. All right. New business item number number 10, Councilor Cowan Watts.
Thank you, Mr. Chair. So I think before we even consider the actual legislation, the folks have been waiting because there's 4 existing commissions that are under this legislation. There's the Gaming Commission, the Tax Commission, the Election Commission, and the Environmental Protection Commission. I don't know who wants to go first, but we kind of did or didn't get documentation prior to the meeting. But I'd like people to understand how it works before we even start amending it and who's in compliance already.
Mr. Hummingbird seems the most eager to go.
Very good.
You know, go for the biggest target in the room. I do have a handout prepared for each of the council members, and I also have one for the staff to take. We've got plenty here. What I'm handing out, just if I could, Mr. Chair, just to give a brief rundown of what is contained in this. The memo on top contains a summarized, bulleted version of the process that we generally follow. Behind it is a list of actions that we've taken in the last year. Behind that table are 3 separate flow charts that we have provided not only to our commission as a visual representation of our rule and regulation adoption process, but we've also shared this with the members of management at the casinos. And it outlines the standard process for adopting rules and regulations, the emergency process that's provided for within the APA, as well as the hearing process that is provided within the APA. So, in general, we have employed every measure that we know of to comply with the APA since its inception in its current form since 2006. So we hope that we have met with the council's expectations when it comes to complying with that act.
Yes, Councilor Cowan Watts.
Thank you, Mr. Chair. After I reviewed the APA, the only thing that I kind of had and then your documentation, and thank you, was the only thing that I had a question about was this really helps establish for our constituency and any affected parties as well as elected officials with these independent commissions, the way we all should operate together and make each other aware. So the only thing I can even think of that maybe caught folks off guard to some extent, you may have an answer, is how the Gaming Commission and then included tarot vendors, that they also had to be licensed. So in that case, I would have thought the APA would have had us reach out to the tarot vendor to say this is a coming policy change that's going to affect you. They didn't even, and you may have, and they just didn't pay attention. So that's the only missed opportunity potentially, or something that didn't seem to work under the existing APA law.
Okay. Yeah, and I wish I had a good answer for you, but the only answer I have is that when I've read the APA, what we have been required to do when it comes time to post a proposed rule is to provide not only a copy to this body, but to the administration as well at the same time as we make it public. To do any extra of that, I'm not saying that we can't do that, it's just that our standard practice has not been to reach out to really anybody, just making it public, and if anybody wants to comment, they can. There's probably better ways to make that outreach a little bit more easily accessible by the members of the public, but at this point, the efforts that we've undertaken have affected mostly just the gaming facilities themselves. The issue with regard to licensing of vendors, particularly anybody that may be tarot certified, is something that we were bound to do under the new, or I say the Travel State Compact that was done in 2005. There, we have met with just a few individuals as part of our licensing process when it comes to tarot, but when we initiated the vendor licensing process, there was only 3 designations that we had to come into compliance with, and that was anybody that was going to be spending $25,000 or more in the coming year with the operations, or that had already spent $25,000 or received $25,000 from the gaming facilities in the past year, for non-gaming vendors, and then for any gaming vendor, it didn't matter the level of business. So once we have crossed that threshold with them, We've gotten all of our gaming vendors taken care of, and we deal with the non-gaming vendors on a case-by-case basis. So if C&E decides that they want to use a tarot company, we don't know that until after they either go through the bidding process or have some way to award a contract to that company. And once they do that, then we start the process with them. So I'm not sure if that really addresses your question or not.
When I reviewed the APA, I thought there were a couple of opportunities. One is if we know that there's a class of people, the way I read it, if there's a class of people we know are going to be affected, that we would reach out to those people. And then the second, well, there was actually three things. And then the other thing is, in general, in the public, like what you've provided here, is that something if we go to the Gaming Commission, we understand it's put on the public notice and there's an RSS feed that can be done.
Yes.
But then if I want to know what has the Gaming Commission done per the Administrative Procedure Act, can I go to a place online and just look at the history of how policies have changed? And then if there's exceptions to anything, those would also be posted the way I understood it under the APA.
If there are, as far as the first part of your question, is there a place that an individual can go to look at the history? The only place right now that I know of is on the tribal website where it is under public comments or public postings. I don't know if there is a separate location where it tracks all of our changes to it. We do maintain a complete and comprehensive list of all of our rules and regulations, which does include an archive section for our old rules and regulations. So once a new one gets adopted or is replaced, the old one will go into an archive setting and the new one will take its place on the main website. So you can access the Gaming Commission rules and regulations via the Cherokee Nation website. So
as a public person?
As a public person. We do maintain a separate website for my staff to use, but it is nothing different than what's on the public website.
So I think that, because that's the way I understand it, it says that, I think the Act reads that IS will maintain the historical record of all policies and their changes and that process.
And I also have an administrative officer on staff that serves as my APA officer that maintains the hard copies of all documents since we have been operating under the APA.
Thank you so much.
Okay.
Were there other entities that you wanted to hear from? I know you've invited.
Yeah, there's three others that are here. So the Tax Commission, the Election Commission, and the Environmental Service, or I guess Terry Hills from the AG's office is representing the Environmental Protection Commission.
And Councilor, I don't want to get ahead of ourselves, but I appreciate what you've done here and think it's going to take a lot of discussion. I wonder if we can hear from some of the folks and then get some more action next month. Would that be acceptable?
Absolutely. That was my plan. Thank you.
That'd be great.
But if we can hear from them since they've been sitting here, that would be
They
great.
have been sitting here, so if they could give us some brief statements, that would be
Well, mine's very simple. We do try to follow the APA. I've given her a list. I didn't get it out to everyone. I apologize. I've been at a conference all week, so my communications has been via my iPhone and my iPad, so I apologize for that. But it's very simple. We do keep all the records in our office. We have someone that follows that. Everything is posted out on the public site. There is not, as Jamie said, there's not a place where it just gives the tax commission. It's just under that one. So the only thing, and I did suggest this to the counselor, the only thing that I know might make it easier is if there was a place on the website when you go to the tag office, then you could go and it would have like our minutes of our meetings and it would have all of our rules and procedures or any legislation that had been put out there under the tag office and not just under public notices. That'd be the only thing I would know that might help them if they were researching something specific to the tax commission. So.
Okay. What do you have on deck, Councilor?
I think the Election Commission's up next. Thank you.
I also have a very brief report because we haven't had an Election Commission meeting since this request was made of us. We meet this afternoon at 4 o'clock. It was a posted meeting like all of our meetings are, and we'll prepare a report and have it to you as soon as our meeting is over.
So you'll email it to them?
Yeah.
Okay.
Yeah.
Thank you very much.
You're welcome.
I believe it's the Environmental Protection Commission.
I had Tom Elkins couldn't be here today. He asked me to come on his behalf, and he has a written report. I think Todd's got my copies. It's very brief, but if there's any questions or information that I can get for you, I'd be happy to write. I'll give you, if I can answer off the top of my head, I will. If I can't, I'll take notes and get that information back to you as soon as I can. They're not a particularly active rulemaking body. They haven't made any rules, I don't believe, since before the APA was passed. But they do post their notices. Laura Adair keeps records of all the EPC meetings and the minutes. At every meeting, they make sure to note and acknowledge that the posting was properly made, and they do have time for public comment at every meeting. So there's opportunity for public input if there's anyone who's interested in doing that. So.
So, and I should have asked this of Jamie too, I think it's very important as we become a more sophisticated, functional government, that those commissions are given authority and such that those meeting minutes are also published, because I think that's the way I read the APA, their requirement.
Yes.
But I haven't heard that from the reports that those are published.
The commission minute meetings are published. They are posted out there after every meeting.
And online?
Online,
requirement.
at the public, and then the public notices is posted out there.
I know that they have a website, and I know the EPC rules are posted there. I don't know as to the minutes, and that's something I'd have to check. I'm just not as familiar with their website as they are, I'm sure, but that's information that I can check and get back to you.
Okay. I think Jamie is
Well, as far as our minutes go, those are publicly available, but we have not been posting them on the website, but I will make sure that they do get posted from here on out.
Mr. Chair, just to kind of wrap this portion of the discussion up while they're all here, I don't know if it's something I can work with the Speaker, the Deputy Speaker, the AG, and our council attorney, but there's almost like a checklist that needs to come out of the existing law to make sure that every detail's in compliance, because that's part of the APA is the level of detail, to make sure that the constituencies affected are fully engaged in that process.
Well, I'd suggest tabling, and then we can work on the next month.
But is it before it is tabled, I still have the floor, thank you. That would be a good path forward so we can move on for next month? That's something you'll work, okay, I make a motion to table then. Sorry.
All those in favor say aye.
Aye.
All opposed, same sign. Aye.
Thanks for coming.
Thanks, Jeff. Thank you.
Thank you, Councilman Watts. Madam Speaker,
Yes.
new business item 11.
Yes, I would like to make a motion that the Tribal Council is authorized under the Constitution, I believe it's Article 6, Section 6, to enter into an executive session for purposes in which to discuss some employment issues.
It's been moved. Do we have a second?
Second.
Second. All right. Point of order, Councilman Ford.
Point of order is, I'm going to get Todd to agree to the executive session. I think it deals with retention.
Personnel matters. Give me a copy of the Constitution. I usually have one handy, but I don't.
I think the exact words are concerning employment, retention, or discharge of personnel. And this is under the employment part.
Which part, retention?
No, expanding.
Discharge?
Expanding employment.
Councilman Ford
I
still
think
has the floor.
it's qualified. We'll let the AG tell us.
Article 6, Section 6, a meeting of the council and its committees shall be open to the public except A, when the discussion shall concern employment, comma, retention or discharge of personnel. Employment, and obviously you won't know until you get it in there because of the vagueness of the notice. But in executive session, the only two things you can talk about is the employment, which would be to employ, or the scope of employment of a person, or the retention or discharge of personnel. Now, I would argue that if you were going to hire new people or discharge anyone, that person's name would have been specifically listed on the notice. So therefore, it would be my unofficial shoot from the hip opinion, that you can go into executive session to discuss employment of an individual, which would include scope.
Madam Speaker, your motion is in the nature of discussing the scope of work. It's
Yes.
not. All right. Councilman Thornton, does that resolve your point of order?
No.
Or do you object?
I'll object.
Okay. You've objected, and you can object to the form of your vote. Councilman Councilwatts?
I will.
I also object because we do not have, like, it should at minimum name who's involved, I think. There's no, like, there's not a specific enough agenda item to really take any action today. That's what I was concerned about.
I can understand your concern. Mr. Attorney General and Ms. Barker Harold, I
Let
have a question.
alone the subject matter.
I have a question for both of you. The Constitution is not that specific, and we have no statute that is that specific. We run the risk, as we always do in procedure, of moving forward in an area that perhaps the Constitution or the statute would have used vague, and that risk is that someone may come back and sue, and they may say you did wrong, or that we violate the Open Meetings Act, which is beyond just a lawsuit. It's a very serious matter. However, my sense is that we can take this action, that it falls within the scope of the constitutional language you just read. So I'm prepared to support it, but if you or Ms. Barker Harold have any further guidance before us before we take action.
Well, and I would defer to Ms. Barker Harold, but you've heard what I just said, that if you go into executive session, I think you are limited because you didn't mention you cannot hire or discharge anyone because of the specificity of the notice. The only thing you can go into executive session would be to discuss the scope of employment of one of your employees.
I think we're within that safe harbor. Ms. Barker Harold, do you have any further guidance for us?
I would concur the same thing, that as far as discussing the scope, that you don't have to name the employee. Only a discharge or a hiring do you have to name the employee.
Very good. That's it. Any further discussion on the motion to go into executive session? Hearing none, we'll take a vote. All in favor of the executive session, say aye.
Aye.
All opposed, same sign.
Aye.
Roll call.
John Garvin?
No.
Frankie Hargis?
Yes.
Chet Huskin Jr.?
Yes.
Connie Boyd Jordan? Yes. Lee Peter?
No.
Dick Light?
Yes.
Curtis Snell? David Thornton?
No.
David Walkingstick?
Yes.
Kara Callan Watt?
No.
Bill England?
No.
Jack Baker?
No.
Joe Byrd?
Yes.
Julia Coates? Jody Fishinghawk?
Yes.
Meredith Fraley? No. Janelle Fulbright? Yes. We have 8 yes and 7 no. And I didn't.
Councilor Snell, was that approved? All right, the motion carries. Shelley, do we need a moment to prepare for executive session, or are we able to transition to that?
We need to allow him time to stop the stream, put in the executive meeting, for all of the audience, and hopefully, I don't know.
Mr. Chair, under the Freedom of Information Act, before it's section 75199A or B, before going into executive session, the public agency shall vote in public on the question, and when the vote is favorable, the presiding officer shall announce the specific purpose of the executive session. As used in this subsection, specific purpose means a description of the matter to be discussed as identified in item 1 through 5 of subsection A of this section. And it talks about all of that in detail. However, I don't know, it's going to take a lawyer. And I am not that.
Well, we have one at our disposal. I would entertain a motion to recess for 5 minutes, which will give us time to prepare for executive session, and if need be, we can reconsider the motion because we've not actually entered into it yet. So I entertain a motion to recess for 5 minutes.
So moved.
Second.
All right, all in favor say aye. All opposed, same sign.
Recess.
There
Recess
it
for 5
is.
minutes.
Confer. Let's
Okay.
confer.
back in order. We had taken a vote to go into executive session. We had not gone into executive session. We are not in executive session, so all minds are clear. Madam Speaker.
Yes, I would like to withdraw my request and make a motion for adjournment.
Second.
All those in favor say aye.
Aye.
All opposed, same sign.